Hello, my true crime lovelies. How are you? Oh my God. The state has clapped back. There is so much clapping. It's more clapping going on than in a house of ill repute. Okay, let's just get right into it. Lighting is bad. Hope audio is okay. I'm connected to the internet, but I'm trying to get these things there. Yeah, anyway, let's just go. Okay, first one. State's response to defendant's motion for return of property or in the alternative motion for independent exam by defense comes now the state of Florida by and through the undersigned ASA and states and alleges as follows. The defendant's assertion that her prior plethora of attorneys, oh, not the shade of attorneys, had no opportunity to see or review her cell phone is patently false. If they never chose to avail themselves of a retained digital forensics expert of the opportunity to inspect the phone, it was of their own volition. Do you hear all that clapping? The digital image of the phone has been disclosed in discovery. The defendant can choose to attempt to enter portions of the digital imaging, like the state, at trial. The state will introduce the physical device into evidence at trial. While it appears to be axiomatic, oh my God, that a court cannot order the state to release evidence it intends to introduce in trial. Oh my God. While it appears to be axiomatic that a court cannot order the state to release evidence it intends to introduce in trial, it apparently bears repeating. We're going to say it one time real loud, people in the back. As a matter of course, courts should not order the state to return property lawfully seized pursuant to a valid search warrant where the state is actively conducting a prosecution, and they came with the receipts. State v. Williams in the Florida 3rd District Court of Appeals, 1996. See Glendale Montessori School, Inc. v. State, Florida 4th District Court of Appeals, 1994, and also see Alvarez v. State, Florida 3rd District Court, 1986. So, yeah, 2 times on appeal, whoever the Glendale School lost this and the Alvarez lost that point, and then State v. Williams made that point in hail to the no. The state has explained to the defendant in open court, i.e. on the record, and even I heard it, Mr. Cacciatore and Mr. J, that she is permitted to have an expert examine the phone at the sheriff's office under the supervision of the sheriff's office in the state attorney's office to maintain the integrity of the original evidence. She, of course, is permitted to do so. Florida Rule of Criminal Procedure 3.220. Therefore, the court should deny the defendant's request to return the evidence to the defendant. The defendant's latter wish was already agreed to by the state, and we await coordination with the defendant's latest counsel and any expert she retains. So that was sent to Owens, Beck, and Henderson, signed by Jay. I thought that was Mr. J. I like his flair. Go ahead, Mr. J. Basically, the summary of that is, why y'all playing with me? Why? Why y'all playing? Okay. Now here we go. This is the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome, aka BSS. Comes now the state of Florida by and throughout the undersigned assistant state attorney and states and alleges as follows. The defendant files an amended notice of intent to rely on the defense of battered spouse syndrome on September 15th, 2024. The defendant was provided discovery over 4 years ago. By the defendant's own admission, her expert, Dr. Julie Harper, saw her in 2020. The discovery in this case shows that the decedent and the defendant engaged in alcohol-infused spats of violence against one another periodically. Not alcohol-infused. This no more. Oh my God, am I showing you guys the screen? I'm not. I'm getting too excited. Okay, at least I remember before I got all the way through it. Okay. Here's the alcohol-infused spats. This no more describes the criteria for battered spouse syndrome than a mental illness describes insanity under the McNaughton rule. Uh-oh, I like that name, McNaughton. The conclusory statement that, in particular, the evidence will demonstrate factors that trigger BWS, the physical symptoms experienced during BWS, the distinct behavioral and psychological symptoms exhibited by the defendant that are consistent with the person who suffers from BWS, and the impact of BWS as it relates to the facts of this case does not set forth the particular evidence that shows the defendant suffered from this syndrome. In short, in summary, go pound sand. The state's concerns that what the defendant is alleging does not meet the criteria for battered spouse syndrome is not premature. The discovery does not support a diagnosis of battered spouse syndrome, and the defendant has not alleged new facts to support battered spouse syndrome. Battered spouse syndrome is not actually a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable. To show, in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. Okay, true crime lovelies, you and I, we did the research about that imminent death. A lot of people were coming here saying, oh, you don't know, it's not imminent death. And I would refer them back to the conversation we had. So we are on point. We are understanding the facts. We understood the assignment. Okay, so you have Akindo v. State, Florida 2nd District Court of Appeals 2023, so last year, hot off the presses. Review granted, Akindo v. State, Florida, October 30th, 2023. C. Wien v. State. This, I think, is what a lot of people rely on, or not a lot of people, not like the mailman, but in the court. There is no evidence of a justifiable use of deadly force in this case, and the defendant has not alleged any such new evidence in her notice of her intent to rely on battered spouse syndrome evidence. What the defendant told law enforcement was, when asked about the decedent's other industries, when asked about the decedent's other industries, in all honesty, we have not gotten into it. Paragraph 3, statement 22520. The defendant said that she and the decedent were having a good time on Sunday, having wine, painting, doing puzzles, and listening to music. Nobody laid a hand on nobody. And then C, I have not touched him. We had a good day. It was a good day. We've had good days lately. There was no ill will between us last night. Last argument was maybe last week. I was so happy, like it was such a good day. I kid you not. Nobody touched nobody. Nobody touched nobody. It's the drinking. That's what it is. It's the drinking. I thought he was okay. Everything was fine and dandy. Question, why didn't you let him out? A, to be honest with you, I don't know. K, I will never drink again. L, question, what was your motivation for leaving him in the bag? A, I didn't have any motivation. It was me, he and I having a great day, fooling around and being stupid, and apparently me going upstairs and going, I'm blaming it on the wine. Question, you two didn't lay hands on each other? Answer, no. And I don't have any injuries. He and I have not been at it with one another. She didn't do this intentionally. Alcohol is a shitty thing. So it's like, okay, so while we're in a good place right now I'm going to snap. Is that what it is? While we're in a good place right now, see, that's the thing. But you clearly can tell that I have been drinking some. I didn't touch him, nor did he touch me. The defendant's account is not one of self-defense, but rather an accident. Wagner v. State. BSS is not itself a legal defense, but evidence that the defendant suffers from BSS is admissible in Florida to support a claim of self-defense when the defendant is charged with a crime against her abuser. If the defendant has changed her account, she is not alleged such in her amended notice of intent to rely on battered spouse syndrome evidence. Therefore, the state renews its request for the court to strike the defendant's amended notice of intent to rely on the defense of battered spouse syndrome. It does not set forth with particularity the evidence that would show the defendant meets the criteria. Additionally, the state renews its request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial. Ladd v. State, Florida, Second District Court of Appeals, 1990. Defendant's argument is that the trial court thereby improperly required defendant to testify. We disagree. The trial court did not err in determining that no other testimony provided a predicate for that expert testimony. Thus far, the state is aware of no evidence supporting the defendant suffering from the syndrome, only evidence of alcohol-induced violence between both the decedent and defendant. And that's when they get into court is where they're going to roll that beautiful bean footage of all of the body cam footage when Sarah called the police. There is zero evidence that this was a justifiable use of deadly force. The defendant has stated the exact opposite, and she is the only one who can testify that it was a justifiable use of deadly force. I certify a copy went to Mr. Owens, Mr. Beck, Mr. Henderson, William Robert J., Assistant State Attorney. Signature. Yes. Okay, that is, I got to get out of here because I got to get to the doctor. We are getting close. The only reason I came in here was the only reason I went to the court docket is because I was trying to make a thumbnail about Mr. Oh God, what's his name? Michael, I can't think of his name. I wanted to know what his exact title was so that I could make a thumbnail for that. But then I found this little treat. So there you go, guys. Thank you. I appreciate you rocking with me. Talk to you later. Toodles.